Hello?
Hello.
Hello?
You've reached the court. Just be patient. It'll be online in about 5 minutes.
Okay, thank you.
Video is on, please.
I don't know how.
That's my client, Your Honor. If Your Honor has no objection, I don't mind
That's
if you
fine.
just step off.
All right, and we have Ms. Earlywine under the docket. That's what you're called, and so I need to refer you to as that, just to keep a clean record. All right, so Ms. Bliss, go ahead.
And Your Honor, this is my request for a motion in order for default. Ms. Earlywine or Tolshog was present at the temporary orders hearing. She has not filed any responsive documents despite being at that hearing. I've since attempted to resolve this matter. She's not responded to any of my correspondence. So at this point, the only way forward essentially is to make a request for default or set the matter for trial. I think procedurally, the fact that she hasn't filed any sort of response warrants this request today.
I did actually try to call you 2 different occasions. Most recent one was on Saturday. I don't feel the need to file anything. Again, I've already stated that I do not want to continue any communication, contact, anything with Phoenix due to my own family's safety, mainly my son. The disdain that she has for me and my son, I just don't feel is a healthy relationship to continue. So again, I don't feel the need to respond. I've already stated that at the last court hearing after I'd stated that somebody tried to attempt to serve me after they illegally trespassed on my property.
So you need to understand that if you do not respond in the legal proceedings, I'm going to be signing off on a default, which means that your ability to have a say in the outcome of this case goes away. You've lost that ability. And so by not responding, is that still your intent, not to respond in writing to the petition?
Yeah, I'm not responding to any of that. Like I just stated, I've already stated I don't want to continue any contact, communication, relation, anything. I don't feel the need to respond to lies. I could respond with a whole bunch of pictures off of her phone of stating abusing and bruising that were downloaded from Safari. Again, it's just lies. I don't respond to lies. I'm not, no.
Right.
Continue how you please. No.
All right, Ms. Bliss, I don't think there's any choice then but to sign off on the default.
Yes, Judge, and I did prepare final orders for purposes of today's hearing as well. I'd ask that you sign those as well so this matter can be completed.
So it looks like you've been referred to as Ms. Is it Tolshog?
Polishog.
Polishog. In these papers, first I've signed off on the order on motion for default. In the final order and findings on petition to change a parenting plan or custody order, Ms. Polishog, that's the name that's on here. Are you willing to put approved via Zoom, or are you not going to?
I'm sorry, you were cutting out. I'm in a vehicle. What was that?
I said on the final papers, it has a place for your signature. Do you want me to put approved via Zoom, or do you want me to put refuse to sign?
I'm not signing anything. I already stated that. Whatever you choose to do is what you choose to do. My signature is not going on a packet of lies.
So I've signed off on the final order and findings on petition to change parenting plan or custody order. And on the parenting plan, again, signing off on that order. Signing off on the child support order. All right, so again, I've signed off on the order on motion for default. The final orders as submitted. Putting refuse to sign for Ms. Polishog, and that takes care of that matter.
Thank you, Judge.
And I'm not quite sure how to say the names. Diach or
Deutsch.
Deutsch, it is Deutsch, okay.
Yep.
And it's the Deutsch matter. I'll just leave it at that.
There we go.
All right, anyone else here on that matter?
And Your Honor, I can note The other party was served on the 5th of April, or the 3rd of April, excuse me. And I've received nothing from her since that time. I was hoping that she would appear on the docket today, but it does not appear that she is present. At this time, we asked for a motion for genetic testing, but obviously that's going to be problematic if she hasn't appeared. But I'm still asking for that order, and hopefully we can make some contact with her once we get that order to get some genetic testing done to determine paternity in this case.
I did review the files and record and did not see any response. So with that, I've signed off on the order and motion for genetic
That matters,
testing.
ready?
Thank you, Judge.
Here's the order.
And Your Honor, I don't know if you saw my order that I put in. I don't know where it went. We filed it on the 17th, but it disappeared. I have very minimal issues with Miss Baldwin's order. So it's up to you, Your Honor, if you want to have one that's just from that hearing, or if you want the parenting plan to include it. I can argue either way. Both of them are minimal.
So in reviewing that, I would prefer to just work off the parenting plan. That seems to make more sense. So I looked at both as far as that goes, but let me get that out here. Okay, I'm looking at the amended temporary parenting plan, proposed by Ms. Baldwin. Tell me what your objections are.
Very minimal. And my apologies to Miss Baldwin. This is my dropping of the ball, has nothing to do with Miss Baldwin. She got these in quite early. Section 8B, it just says every first, third, and alternating fifth weekends. Your Honor stated every first, third, and fifth weekends. The word alternating needs to be struck, and that is on, and I did submit the transcripts for this. That would be on page
4.
Yes, Your Honor, page 4. And it's also in the transcripts on page 45 of the transcripts if you want to look.
Yeah. Ms. Baldwin?
Alternate is most common, so whichever Your Honor intended.
Yeah. I intended just fifth weekend. There are only 4, and I was just looking for some additional time is all. So I'll go ahead and delete alternating. Okay.
And then the only other issue that we had was on page 9 under 14H, the telephone access, beginning at the age of 10. I just wanted to make sure that this was still what Your Honor intended. We didn't speak about it. It seems like they are calling the child at different times. I just wanted to make sure that that was still intended, given the expanded visitation.
Ms. Baldwin?
Not argued, pled, or ordered. We shouldn't be changing things that we didn't argue, plead, or order at that hearing. So I would ask we just leave it alone. If the parties want to negotiate something separately, we can do that off docket.
Yeah.
And that's fine.
Okay. It will remain as currently set.
And that's actually my only issue. And again, my apologies to the court and to Ms. Baldwin for dropping the ball on this one.
All right. So with that, Ms. Winkles, are you okay to put approved via Zoom?
Absolutely, Your Honor.
And then I would just ask we also sign the order on hearing that just has the clerk's action in it for the review date.
And that's fine with me as well, Your Honor.
All right. I have signed off on those orders. Anything else?
No, Your Honor.
No, Your Honor. Thank you.
All right. That
All right,
concludes that matter.
Thank you.
Trotter is present. I see Donovan Day and Mr. Anderson. All right, counsel, go ahead.
Thank you, Honor. Again, good morning. My name is Ken Anderson, and I represent Donovan Day. We're asking the court for some relief, and some of it has already been provided by counsel. As the court may recall, this file shows that a temporary order was entered last May. The oral argument was done in February. At that time that the order was entered, the parties agreed that after the home was sold, the parties agreed that it would be, the funds would be put into the IOLTA account of the petitioner. we now do not have an agreement that those funds remain there due to the behavior of the petitioner's attorney's office. We have very serious concerns. I'm relatively new to the case. I came in November, and my first hearing was the presentation of the orders on contempt, and we highlighted that. Frankly, what happened is I had surgery on the very last day for filing that motion for reconsideration. It was the day before Thanksgiving. It was filed late, and the court sua sponte did grant the relief in the interest of justice because the order that had been delivered to the court had incorrect numbers. That my client has purged the contempt. I believe that opposing counsel has acknowledged that, and we look forward to being able to file the satisfaction of judgments. We are asking that the court order the transfer of funds from the IOLTA of the petitioner to that of the law firm where Donovan Day's attorneys work, the Cowlitz Law Group. The court is not being asked to make a determination whether they are community or separate. I did put our position in our pleadings, but we're not asking the court to make that determination right now. We are asking also that Mr. Day be able to have access to some of those funds. We're asking for $35,000. We are also asking for sanctions to be imposed here, Your Honor. Mr. Trotter is new to the case as well. I understand that. It was very disturbing for me when I started inquiring about these funds that I learned that the former attorney of record had left the firm. There was no withdrawal or substitution, and no one seemed to know much. It took quite a while just to get the ledger. There were emails saying that they had the money. However, at that point, I just felt very uneasy to represent to my client that the funds were safe. It's taken a lot of time to get the records that should have been provided. And I think we are asking the court to impose sanctions here because under CR 11 that they be imposed against counsel and against the petitioner. Your Honor, this case really needs to move forward, and the guardian ad litem report is in. It's getting ready for trial, and we are asking the court, again, order the transfer of the funds, that there be the ability to file the satisfaction of judgments and the contempt be purged. We're asking for a release of the funds and for sanctions under CR 11. Thank you very much, Your Honor. Thank you.
Counsel?
Thank you, Your Honor. Yes, so as Mr. Anderson provided, I am newer to the case. However, I would like to kind of go through a few things here. We first request that the court deny the motion. The court made clear in its order that specific funds were to be distributed to the IOLTA of the other firm. Those specific amounts were allotted in the order. And as you can see from the pleadings, Mr. Anderson's request of me in our initial communications was with respect to an opinion as to community or separate property. So I firmly believe this motion is here only because he ultimately did not like the response, which was we're not turning over all the funds because it's yet to be determined whether or not those funds are community or separate property. I do agree that the court should, as we have already provided, we've provided those funds to Mr. Anderson's firm as of today. Also through the pleadings, you also notice that we provided the information Mr. Anderson requested as to funds dispersed from the account. There was nothing dispersed from our account. It was not only until we received the account balances from Mr. Anderson's firm that we then provided that money to the IOTA. So I ask that while there has been some delay in working out our communication, I feel that we can move forward with an understanding. So I ask the court to deny attorney's fees and sanctions for that reason, and also to deny the motion. Thank you, Your Honor.
All right. Mr. Anderson, anything further?
Briefly, Your Honor, as I said, I appeared in this case for the contempt hearing. And had I known then what I know now, one of the first, I think, factors in contempt is that the moving party have clean hands. And that just wasn't going on in this case, Your Honor. The petitioner had access to these funds through counsel. $22,000 was ordered to be paid. It was not. My client was on the line for all of these debts. He's been making his payments. Your Honor, we are asking that the funds be transferred, that there be a release of funds, and that terms be imposed. Thank you very much.
So I have reviewed the files and record and the court rules as follows. In regard to the transfer of the remaining funds, Mr. Trotter is an officer of the court. Compliance was made in regard to turning over the accounting as ordered by the court and by the time of the court. So with that, at this point, the court is not going to be transferring the remaining funds. If there are any additional or further problems in regard to this, then the court will reconsider and look at that. Given the compliance with that order, the court does not see any need to move these, as I said, see the funds further. However, the funds are not to be dispersed without court order. That in turn requires that $22,000 to be dispersed to the IOLTA, the Callis Law Group, for the purpose of reimbursing the respondent for those sums paid by him to pay the bills as previously ordered. So that needs to be done if it hasn't been done already. As to attorney's fees and costs, the court does find that the respondent's attorney has had to expend significant time trying to obtain an accounting of the funds, the payment of bills as previously ordered in 2023, and simply having to pursue things that should have been done without further court intervention. So the court does order attorney's fees and costs of $8,000 to be paid by the petitioner within 10 days of today's date. The fees are ordered to be paid from the funds in the IOLTA account. The court does reserve additional fees can be requested at the time of trial. So this is just a preliminary amount, and Mr. Anderson's client can request additional fees, as I said, at the time of trial.
Thank you, Your Honor.
Thank you very much, Your Honor. Thank you,
right.
counsel.
So do you want to set it on for presentation today, or what would you like to do? Do you want to see if you can work it out first and then?
You know, Your Honor, I believe that my working relationship with Mr. Trotter is that we will be able to work this out rather than put it on the docket.
Okay, all right.
Great.
We will leave it at that.
Thank you.
All right,
Thank
thank
you.
you.
Thank you, Your Honor. Thanks,
So
counsel.
there are two matters that are on for today. One is the contempt matter, and the other is the request by Mr. Jackson for temporary orders. That said, counsel is here just for the contempt matter. And I can hear argument, but I'll tell you, I don't think this matter is ready to proceed to hearing today. I know this matter has been set over for a variety of reasons. So you can hear what I have to say, or I can have you do argument and I'll get to where I'm at. So that's where I'm at this point. So what would you like to do?
Your Honor, on behalf of my client, I appreciate the court's candor, and I will follow the court's directive. If you would like to, if the court would like to address, anything further, I'm happy to hear it. And alternatively, my client is willing to, take a continuance and appropriately hash it out procedurally. I'll defer now to the petitioner what they may have to say to you, Your Honor.
I'm fine with this. The only thing that I would like to say was I got yesterday the paperwork from Mr. Lee, and he wrote in there that petitioner filed an apparently frivolous ethic complaint against Judge Michael Evans, which was included as an exhibit of declaration filed on February 29th, as the basis to disqualify Judge Evans. I never did that.
Okay.
So I just wanted to clear that up before anything else is that this was not on me. I would never go against any charges.
Okay, I wouldn't consider it really anyhow. So again, understanding there are two matters, and at this point the parties have been pro se, and so what I'd like to do at this point, again with an attorney on board for Mr. Jackson on the contempt matter, the problem the court is having as it relates to the contempt versus the modification is a lack of documentation by Mr. Jackson A couple of overdrafts is insufficient to show what is actually going into his account. Mr. Jackson also claims medical conditions as a reason, but the fact is he is still working. And again, the information that is provided is insufficient to show anything any differently. As well, it appears the same job has been in place for quite some time. So to essentially reconsider and modify the order of a prior judge is not likely to happen without a great deal more in documentation of both the medical and even more so the financial part of this. It's really primarily the financial part that I'm looking for. The court understands the parties have been representing themselves. So what the court wants to see are 1, copies of the full bank statements for Mr. Jackson for the past 12 months. 2, copies of the 23 and 22 tax returns. I know there was one in there, but I think it was 2020. And 3, copies of the paychecks for Mr. Jackson for the past 6 months. There's no reason not to provide this documentation under seal and file them with the court within 2 weeks of today's date. I'm setting these matters because there are the 2 matters over to May 28th. Mr. Lee, does that work for you, the 28th?
Yes, it does, Your Honor.
Okay.
Same, I don't have a calendar in front of me, but I assume that's the same docket.
It is.
Thank you, Your Honor.
To make a ruling on the contempt matter, including the non-payment of maintenance and the failure to vacate the residence. And so understand if you fail to provide the documentation, I'm simply going to go forward at that time without anything more. But I want to have a full picture of this before we proceed forward as to what should actually be happening. So do you want me to say again what those documents are? So copies of the full bank statements for Mr. Jackson for the past 12 months. Copies of the 22 and 23 tax returns. And copies of the paychecks for Mr. Jackson for the past 6 months.
Your Honor, one question.
Mm-hmm.
When you say the bank statements, that means all of his banks,
Correct. All banking,
all banks.
all banks. And then at that time, the court will look at the motion for contempt and the motion for modification. And again, I'm saying this in part because they've been representing themselves pro se.
Very well. Thank you, Your Honor.
Thank you.
Appreciate it.
Your Honor, one quick question.
I can't talk to you without them here.
Okay. You know, it was just something else about the recording that was getting done in here while we were in the court.
Are you wanting a copy of the recording?
No, somebody recorded our thing on her cell phone. Is that allowed?
Okay, I'll bring it up next time we're
Thank you
here.
so much.
Okay. Marcotti, I don't know if I'm saying that correctly.
Marcotte, Judge.
Marcotte. I'm just not hitting the correct names this morning. All right, who do I have on this matter?
I'm present on behalf of Ms. Marcotte, Your Honor, Deanna Rush.
Okay, and you're going to have to remind me, is it Kale or Call?
It's Kale. Thank you, Your Honor.
Okay, thank you. All right, and Mr. Zandy is present here in the courtroom. So this is on for review hearing for guardian ad litem compliance hearing. Ms. Kale, can you tell me where things are at this point?
Yes, both parties have responded with their intake packets. I just received them at the end of last week. I've also been receiving testing for Mr. Marcotte, as was requested. And so at this point, we're right on track. I've scheduled both of their home visits and interviews for the week of the 20th through the 24th. And so I'll meet with each of them for a couple hours and interview them. We're right on track to be where we should be at this point in the process.
Okay. All right, Ms. Rush, anything from you?
Nothing in addition to that, Your Honor.
Mr. Zandy?
No, Judge.
Okay. All right, so that takes care of today's matter. I apologize, I meant to call it earlier, but appreciate that. And hopefully if things don't continue smoothly, just note it on, we'll take it from there.
Will do. Thank you, Your Honor.
Thank you, Garcia.
Thank you.
Good morning, Your Honor. Natasha Tahovac, present for petitioner.
That'd be just a second. I have the objections. Thank you for putting those together. Number 5B.
Yes, Your Honor. So during the hearing, you did state that in the final parenting plan, decision-making is reserved. So I'm just requesting that that sentence be included in the temporary parenting plan.
The part about ability to share in decision-making reserved on petitioner father's ability to share in decision-making once he gets to know the child more?
Correct, yes.
Mr. Zandy?
I don't think it makes a huge practical difference, Judge. This is a temporary order, and by its very nature and design, that's subject to be changed and tweaked on a permanent basis. So I think that would certainly qualify if the court deems that necessary to put it in. I'll leave that to your discretion, but I don't think it really changes the basis of the order at all.
Anything further, counsel, on that one?
I just think it would just be good to include that just to show that there's no prejudice against father for decision-making in the future. But if the court decides not to include it, that is fine as well.
I don't think I'm going to include it because I think it could become confusing at a point of conflict later if, father thinks he knows the child now and should be making decisions too. I think that the order needs to be clear, and so I'm not going to include that. All right, number 8A.
Yes, so the parties have come to a mutual agreement based on the alternating Sundays that you have ordered. So I'm just requesting for clarification that the parties include that father's alternating Sunday parenting time begins on April 21st, 2024.
Any objections to that?
And the only thing I would say again, related to the clarity issue, would be that was never specifically ordered by the court. Now, my client is in ready contact with me, and we do communicate frequently, even though we were moving offices last week. But nonetheless, I think they've already gotten on that track. This was several weeks ago, and the visitations have gone by design. So I just don't have confirmation from my client specifically related to that issue. Again, based on the timing of the office move coupled with when we received this objection to the order, I don't think it's an issue. I don't think it needs to be specified. But again, if Your Honor thinks otherwise, I'm happy to include it.
So on this one, I do think it needs to be included. I think for just in case there's a need to enforce the order, it's best to have a date of commencement. So I would like to see it included. I'll go ahead and write that in if that's okay with everyone.
Yes, I prefer that, but thank you.
Yes, thank you, Your Honor.
All right, let's see, that brings us to one final. Paragraph 14.
Yes, so father does not dispute providing his work schedule to mother. We are just requesting to change the word immediately, since that can be a bit vague, into him notifying of any scheduled changes within 24 hours to mother.
Mr. Sandy?
Yeah, the problem with that is the construct. This is the case in which my client gave you detail about concerns regarding daycare and such. My client also has a work schedule that she's clearly responsible for getting to work to and from on time to pick up the child. Court did say immediately. I think that was what is transcribed in the order as well. So we would ask that stays the same because time is of the essence. Thankfully, we live in 2024 where there's text communications, there's direct messaging, there's cell phones where it's very easy for people to reach out to one another. In the parenting app, if that was included, does the exact same thing. So I think either way, maintaining the immediacy of that order is important. We would ask that that stay the same just for planning purposes alone on my client's behalf to affect the child.
Anything further, counsel?
Yes, so Essentially, I'm just a bit concerned that this would open up the door for a motion for contempt if father does not notify mother immediately. Of course, if there is a change to schedule that needs to be made, father will do that, especially if it's, that same day. But I don't think his work schedule changes within 24 hours. So he would give mother notice.
So at this point, I'm going to leave it just as immediate. I understand the 24 hours and that part of it. At the same time, I think, it can really vary for workers that have changing schedules, and understanding the mother needs to know as soon as possible for her own schedule. So with that, I'm going to leave it as currently set.
Very well, thank you.
Thank you, Your Honor.
All right, so with that, counsel, are you okay to put approved via Zoom for you?
Yes, that's fine.
All right, I've signed that order. That's it for that matter.
Thank you, Your Honor.
That matters, ready, Judge? I believe my client's in the courtroom. Go ahead and come on up, Jamie. I don't know if we have Ms. Joplin.
Ms. Joplin, are you present? All right, counsel, go ahead.
Thank you, Judge. And for the record, Carly Bliss on behalf of James Pulver, moving party in this matter. Before the court today on my client's request for adequate cause and a parenting plan for 7-year-old Vinny. Obviously, I'm imagining the court has had the opportunity to review the files and records. There's some very concerning behavior in mom's home and within mom. My client cites several different concerns regarding potential mental health episodes and or substance use. My client is requesting primary custody of the child, Vincent. At this time, there was an immediate restraining order entered in this matter in March. After Ms. Joplin was admitted to St. John's on an ITA hold where she was there for a week. Since that time, her behavior has continued to be erratic. My client has provided substantial documentation to Your Honor to document this. Recent text messages that were we were unable to ascertain exactly what she was trying to say, but it seemed to be the effect of she was violating the restraining order by walking around outside my client's home, texting him, calling him, trying to make contact with him with a current restraining order in place. Again, obviously, there's some significant concerns regarding her mental health and or substance use. We are asking that she be required to have a mental health evaluation, specifically a psychological evaluation with parental risk assessment. I think that's appropriate given the concerns documented in my client's declaration. We're also asking that she be required to submit to a hair follicle and substance use evaluation. Again, my client indicates there's a history of methamphetamine and pill usage. We're concerned given the statements of Ms. Joplin of people coming through her floor and paranoia of cameras being planted on her property and that she may have a brain tumor, and then the allegation of her saying, I didn't try to kill my mom out of nowhere. There's just a lot of really concerning statements and behaviors of Ms. Joplin, and we're hoping to ascertain what exactly is the root of that cause. My client acknowledges that she has historically been the primary parent of this child. He does not wish to keep this child from her, but clearly there's some significant concerns. We have a young 7-year-old child. He shouldn't have to be exposed to that. And from the looks of it, he has been exposed significantly already. So we are asking for the relief cited in our motion. I would note Ms. Joplin did file some responses. She had shown up historically to these hearings. We've been on the docket for nearly an hour at this point. So given she isn't present today, I would ask that the relief requested in my motion be granted as is.
So in regard to the files and record, I did review it, and I want to note that the mother did file a declaration, which I read too, that was filed on April 15, 24. So although she's not here today, I am considering her filing. And based on that, the court does find adequate cause is appropriate finding, and so adequate cause to modify the current parenting plan. And with that, the court does order a guardian ad litem to be appointed. That would be appropriate. Who would the next guardian ad litem be?
Twyla Corey, Amy Turnbull, and Karen Lawrence.
Ms. Bliss? Who did you say, Twyla Corey?
Yes, Judge, I said I was fine with Ms. Corey.
All right. So what I didn't know for sure is the financial status. I have this at private pay at the moment for 50/50.
That was my request, just given that we have not received any sort of financials from Ms. Joplin. My client does work modest hours. Obviously, now that he has primary custody of Vinny, his work has been reduced. So we are asking, at least at this point, to do private or county pay, 50/50 with reimbursement, obviously dependent on if we get some financials from both parties.
So at this point, I'm going to make it private pay. I understand the situation. At the same time, I'm not sure the court can reconsider that if the financials come back that they simply don't have enough, and then we'll relook at it. But private pay 50/50, and the restraining order shall remain in effect, subject to some residential time for the mother to see the child as proposed by Ms. Bliss's client. The court is concerned about the costs associated with the supervised time and whether mom can do that. Is there anyone else that would be acceptable?
I haven't had the opportunity to speak with my client as to non-professional supervision. If that's a concern of the court, obviously I'll discuss that with my client and we can attempt to arrange that with Ms. Joplin. I guess if we could just set this either for a review. I don't know if your honor is going to enter the orders that I had prepared for today or if we're going to have a presentation hearing.
I was going to go ahead and order them today. So
Okay.
At this point, I'll go ahead without her being present. It really makes it difficult as well. So I'll go ahead and order as is, but if it's an issue that comes up, I would like to look at it. The psychological evaluation of the mother with input from the father is appropriate. With the parental risk component as part of that. Again, the court's somewhat concerned in regard to the financial cost of those types of evaluations. So it may have to be something that's relooked at again, and maybe the guardian ad litem can weigh in on that. Then when done, copies of the evaluation shall be provided to the father as attorney and a copy filed under seal with the court. The mother shall comply with the requirements of the evaluation. A hair follicle test will also be required, and a substance abuse evaluation with input from the father. And the mother is to comply with any recommendations there as well.
And Judge, the only issue I have currently is the orders that I had presented to the court were from, I think, 2 setovers ago. So the dates on the guardian ad litem report, like the 30-day review, for instance, has already passed. That was dated for April 30th. So I would just request new dates on those if you don't have a problem with that.
Can you go ahead and get me a new order and
Absolutely.
go ahead and just put not present for Ms. Joplin? And then put in the new information.
Okay, I can do that and I'll get that to you for signature today.
Okay. All right, with that, I've signed off on the order on adequate cause to change a parenting custody order, signed off on the temporary family law order, the parenting plan, and the restraining order. I have not signed off on the order appointing guardian ad litem with the new one coming. All right, that's it for that matter.
Very good. Thank you, Judge.
Thank you. We have Ms. Rush, you have Mr. Zandy. Do we have anyone else on this matter?
I can't tell from the Zoom roster if my client is present or not. I anticipate she likely is.
I'm
here, yes.
All right.
And my client is not present today.
Okay. All right. Counsel, go ahead.
And thank you, Your Honor. As the court's aware, I do represent the petitioner and moving party to the motion before you today, namely Eleanor Albrecht. We're asking for you to grant the relief cited in that motion. I think it's largely related to finances, and in particular, what do we do with that Castle Rock house? My client is in some dire straits financially right now. Understood since these parties separated back in June that would be the case, but unfortunately, she feels as though, and I think this is substantiated by the information in front of you, that she is doing literally 100% of the financial responsibility for her husband. starting from scratch. This is a relatively short-term 7-year marriage. These parties were married back on December 11th of 2005, separated back in June of 2023. No dependent children. Basically, it's them and various animals at the Castle Rock property. My client details for you some of her frustration in this. This is a case in which she has continued to work. She's a CNA. She provided you that information, earning about $32 per hour. Works approximately 24 hours per week. That's what she's been living off of. And when I say living off of, I use that in loose terms because essentially 100% of her income has been going to fund the Castle Rock house that her husband resides in with the animals. Meanwhile, in the course of those 9 months, my client's been living in a small travel trailer at her parents' home. The parents have indicated that they plan on traveling and using that for other purposes. And my client, as of this week, is essentially forced to secure a different residence. It was our hope, it was our intentions to have this case resolved by now. You'll get information that's somewhat competing from both parties that states what their efforts to do that were. But long story short, we're not there yet. My client, since June of 2023, has paid the entirety of the mortgage, the insurance, the taxes, the utilities. She's paid for the feed and the food for the animals. She's done essentially everything while getting the runaround from Mr. Albrecht, who informs her, well, it's your job as my wife to take care of me. And despite being well-trained, having a rich work history, he has made every excuse under the sun as to why he doesn't think he needs to work. I think it's important when you look at his history with that. And again, he states in his declaration that he's tried to work, but he's got, again, injuries, or he hasn't gotten the contract he wants. This is a very skilled individual. This is a man who basically earns his living, or earned his living as an advisor for various governmental agencies, detailing for them where the proper location for traffic signs were, stop signs, lights, and various different engineering aspects related to government implementation of these various safety designs. He relies on contracts. So basically the government comes to him and says, okay, we need your advice or your input on a location for an intersection. He gives that. He's 57 years old. He's very capable of working. He's in his peak earning years. And for the past 9 months to 12 months or so, he's told my client essentially, well, I'm not getting those contracts I once did. I want you to support me. Ironically, this is a person who has the skills and the work capacity that would translate largely anywhere. Government jobs, he could advise for some other utility agency. He could go to any of the various local mills, many of which are hiring, and probably walk into a job earning $60,000 to $80,000 per year, which would certainly meet his budgetary need for this home in Castle. My client details for you, and again, it's not really contested by Mr. Albrecht in his response to pleadings, the fact that he really hasn't done any of that. He tells you that he's tried his best to find a job, but he provides no job searches. He provides no applications. He doesn't give you a list of places he's applied, what the result of that was. He hasn't given you any information as to why he's not capable of working. Doesn't really give you a response to why it took him 5 months to 6 months to respond to our initial settlement proposal back in, I believe it was October of 2023. It's prompted this motion. My client can't continue to do this. She's taking her wages, again, $32 an hour, 24 hours a week, putting that towards everything, which is to his benefit. So if we look at this again under the umbrella of RCW 2629.090 on the maintenance statute, she's certainly surpassed any expectations of that. And I would certainly question again, what is his need for maintenance given his extensive work history and his employability. And again, my client has, to her credit, and largely to her detriment, continued to provide for him for these 9 months, hoping that he would transition into a job, and he just largely shows no ambition to do that. If you look at the two residences, my client details for you, and again, there's little dispute to this. So there was a house in the Vancouver area that my client owned prior to marrying Mr. Albrecht, prior to even knowing Mr. Albrecht, which she uses as a rental. The deed is in her name. That house was awarded to her years ago. It's hers. So I think the likelihood of that being separate property is frankly extraordinary. She doesn't make a lot of money on that, if anything. And she has traditionally rented that to her adult son and a roommate who essentially upkeeps, makes sure that the house is maintained, pays the existing mortgage on that, pays the utilities, the taxes, the insurance, and she's walking away, basically preserving that asset. She's now going to be forced to move into that home, and given the circumstances with the travel trailer at her parents' residence and their desire to use that, which is going to come with a whole new set of bills and expenses related to that mortgage. You have the other home, which I think everyone agrees is clearly community property. That's the Sandy Bend home in Castle Rock. And that's one that was purchased during the marriage. That's the one that the party did live in and maintain throughout the relationship. There's no way to sustain both homes, especially with Mr. Albrecht's choice not to work. So our suggestion, there's equity there. So our suggestion of one of two things. First, and probably the preferred method, is we just simply list the home for sale. This is something my client has been requesting for several months since the separation. That makes sense. We have listed 3 potential realtors. We really don't care who lists that home, but we're now in May and we're starting to see the peak season of home sales and real estate transactions. Probably makes the most amount of sense. Take advantage of the market the way it sits now. List that home for sale during the good season, which more buyers are likely to come in and entertain bigger offers. We are asking the court, and again, I'm happy to talk to Ms. Rush about who we should use to list that home for sale, but that needs to happen. Secondarily to that, and again, this is a reluctant secondarily to that, is Mr. continues to live in that home, but he pays the mortgage, he pays the utilities, he pays the taxes, he pays for those animals, and the court strongly encourages him. Again, 9 months seems like a long period of time for him to become employed. The court encourages him to find a job. He doesn't need to land one of these contracts when his skills, again, translate to many other areas in which he can make comparable wages to what he's choosing to do. And again, that would be, I think, secondarily, because my client's credit, if he doesn't get a job, if he doesn't heed that warning, becomes compromised due to late payments and the like, which we just assume to avoid. And again, it's a 7-year marriage. So we believe that one of those 2 options, preferably the first, makes the most amount of sense given the circumstances. That's what we're asking for. A couple of other, again, concerns that dovetail our request related to the home is this personal property inside that house. Both these parties, and I think there's no dispute, are attached to their animals. I certainly understand. I think anybody who's owned pets realizes that what impact they make on one's life. There's animals at the home. You know, my client has suggested, again, discussed this with Mr. Albrecht, a way to equally divide the animals. I think that probably makes sense. Secondary to that, and probably the bigger issue for purposes of the hearing today, is some of the other personal property inside the home. My client tells you that the house, since she left, is in disrepair. There's, for lack of a better term, her concern is that her husband has started hoarding certain things. There's boxes that are stacked up through the hallway to the bedrooms throughout the course of that house, and the property has largely not been maintained. My client is asking that prior to, and I think this will help if the court adopts our proposal to list the house for sale, my client would like a date and a time to go in with some third parties, remove many of those items that she believes are special to her, whether that be clothing and personal effects. They can split the furniture, they can do some of these things, which helps clear a lot of this clutter. It also helps them kind of get on their own track and be on their own way related to living their own separate and distinct lives. And we believe that makes sense. And again, as noted earlier, I'm happy to work and coordinate dates and times with Ms. Rush so that my client can go in there and get what remaining personal property and effects she has, as she's been, again, relegated to this travel trailer on her folks' property. So we're asking for that as well. If the court does adopt our suggestion to list the house for sale, again, we've done some rough math. We do anticipate the house is worth approximately $575,000. It's currently about $332,000 owing on that home, which is going to leave over $240,000 in equity. We understand, and my client certainly is in the same boat as her husband, that they need a little bit of money to transition. Now, we pose that both of them take $20,000 out of the net proceeds to use that as a springboard to rent a place or get an apartment or whatever it is that both of them choose to do, and put the remainder of those net proceeds in a trust account, whether that be Ms. Rush's or my own. Again, I don't have any concern with that, and preserve those funds pending final outcome of the case. That's where we're at. Unfortunately, this motion has been brought. It's probably a little bit later than my client would have otherwise, and I would have otherwise liked to, but we were hopeful back in the fall this case would be resolved because it's really not complicated. We just got to figure out what we're going to do with this Castle Rock home. And up until this point, Mr. Albrecht's done very little to make any meaningful suggestions or become meaningfully employed so that he can take on those financial responsibility, or at least some of those financial responsibilities. And that's what we're asking.
Ms. Rush? You're muted.
Thank you, Your Honor. I apologize. I'm also getting over a little bit of a cold, so I hope you can hear me okay. So I'll be brief. Mr. Zandy certainly summarized, his client's position. This to my client is very simple. I mean, my client's never said that he won't work. My client has never said that he's incapable of working. So I don't know where those phrases come from. My client, number one, has qualified for unemployment. He in fact got back pay. So he has to prove to the state that he is applying for jobs. By his own, what he stated in his declaration, and I guess now they're saying they don't believe him or something, but I don't know why somebody would state this if it wasn't true. He's indicated that he's applied for over 500 jobs in the last year, and he's had 8 interviews since June of 2023. Again, he is receiving unemployment of about $900 per week net. We filed his credit card statement showing that his credit cards are maxed out. So we have a situation here where both sides acknowledge that he's not working. Both sides have differing opinions on whether he should be working or what he's doing with that, but both sides agree that he's not working. So what we have right now is whether the court thinks that he should be or that he's somehow out there not trying hard enough. The fact of the matter is he's not working. The only money that he has coming in every month is the $900 per week. He is, as indicated by Mr. Zandy, living at the Castle Rock property, and his understanding of the parties' agreement or their setup when they separated was she moved out. They don't talk, but she moved out. His understanding was that she was living temporarily in a trailer in Vancouver because their rental, and we dispute the characterization issue, and I realize that's premature right now, but the rental in Vancouver was rented out so that he would stay in Castle Rock and that he would stay there and take care of the animals. I understand Ms. Albrecht is working as a CNA. I understand she's working part-time. My client stayed at the property and by his own count takes care of over 75 animals. So they've kind of insinuated that he's not done anything or that he's just at this property and that he's sitting around collecting things. You know, my client painted out for the court what his average day looks like, where he gets up around 2 or 3 every morning and takes care of these animals. And like I indicated for the court, there's over 75 animals, the large majority of those being chickens and whatnot. So my client is at the Castle Rock house. His belief was they were separating. His belief was he would continue to look for work. The parties did try and settle things. The parties did try and work things out, and they couldn't do that, which is kind of normal in cases like this. But my client continues to apply for work, continues to receive unemployment. So he's indicated that he will continue to pay the bills that he's paying, which are his personal expenses and whatnot. He cannot afford to pay the mortgage right now. And in fact, we would submit to the court that if the court orders him to pay the mortgage, it's simply setting him up for failure. And that's what we don't want. We don't want to set these parties up for failure. We want to set them up for success. He's indicated that he will notify the court and Mr. Zandy when he's received a new job. He's indicated that he doesn't plan to stop looking for work. And he's indicated that he doesn't wish to list the Castle Rock house at this point in time because he doesn't have anywhere else to go. So, I mean, we're saying on one hand that this person is not employed, and that's a fact. And then on the other hand, that the house that he's living in should be sold, and he doesn't have anywhere else to go, especially if he's unemployed and can't qualify for rent anywhere. So we are asking that the court maintain the status quo, which is what my client says the parties agreed to when they separated, which was because she was employed, she would pay the bill on their main asset to secure the main asset at Castle Rock while Vancouver was rented. My client will continue to look for work. My client will have an affirmative obligation to notify the court and his wife when he obtains employment. And we would just ask that the court hold off on ordering that the house be listed. We think that it's premature and that the court go from there. My client, like I said, he'll continue to pay his personal bills. I think the general crux of the issue is the mortgage and the utilities and the housing expenses on Castle Rock. So we are asking that she continue to pay those expenses, and that if there needs to be a reimbursement issue or something, that can be reserved for later, but we would just ask that status quo continue.
Mr. Sandy?
Well, if you do the math on that, I guess this is my concern. He's getting $900 a week on unemployment. That's roughly $4,000 per month from that benefit. Says I can't afford to pay the mortgage on that, but expects my client, who's making about $2,500 per month, to pay the mortgage and utilities on that. So again, that I don't understand the math on that or that logic or line of thinking, but nonetheless, it's an individual who just says, you support me, I don't want to do it. So I'm not sure where that $4,000 per month is going, because it's the same guy who says I've relied on my neighbors to help me pay for my animals that are in my possession that I care for. And they've given me money to do that. So if he's getting this $900 per week in unemployment, again, roughly that $4,000 per month benefit, that money needs to be applied for his sake, just like my client's money needs to be applied for her sake. And I think our suggestion works to that effect. As far as the job searches, and again, we see this all the time where somebody is conveniently loses a job or loses access to overtime, or they're in the middle of a transition in life while the divorce is pending. They say all the time, I'm looking for work, I'm doing what I can, but when they actually hold their feet to the fire and say, where have you actually applied? We get a different picture. And that seems to be, and again, I'm not saying it is, but that certainly seems to look like what's happening here from a bird's eye view. Is somebody who says, well, I've applied to over 500 positions online, and I've had about 8 different interviews since June. And again, we're going back 11 months since they separated, but nobody's called me back. And again, if you look at the information that was provided, typical of Ms. Rush, it's very thorough, it's very detailed. There's a lot of financial statements, there's bank statements, there's information about the mortgage, there's a lot of information in there. But the one thing we don't have is any proof that he's actually applied to any jobs. My client details for you and argues in her reply, provides that information that says he's been saying essentially since this time last year, you're my wife, it's your job to provide for me. I'm not getting the contracts that I want to get. So basically he's saying, I'm not going to take any job unless it works for me. And again, that's these advisory positions through the state for these safety devices and mechanisms that go on the streets to keep us all safe. There's no indication of what these 500 jobs are. We don't know if he's applying at Weyerhaeuser or Norpac or Sportsman's Warehouse or what kind of a scope that it is that we're looking at, but he needs to do something to get meaningfully employed. And in the meantime, he's getting that $900 a week in unemployment. So again, this should be a moot issue. For somebody to suggest, I'm not actively looking for work, I'm applying online, maybe, maybe not. Even what I am making in unemployment far exceeds what my spouse is bringing in. I'm living in the family home with the animals in our bed while she's living in a travel trailer, paying for my expenses and for my standard of living. I want her to continue to do that while I basically just sit on $4,000 that's coming in a month. Again, I think that gives you a pretty good perspective of what's going on here. This has been my client's frustration for the past 11 months, and my frustration since I got involved about 8 or 9 months ago. And frankly, the only way to change it was to bring this motion. And unfortunately, we're here, but this is kind of the last resort. We do think what we've supplied is reasonable given the circumstances, and he has had ample time to find something to do at the age of 57, and he just hasn't done.
So I've reviewed the files and record and everything included in that record. What the husband has to say simply doesn't make sense. As with many divorces, there simply isn't enough money to go around. And at this point, the respondent appears to be voluntarily unemployed. This is the high season for contract type work, so to not report any response to the stated multiple applications makes no sense. To require the petitioner to pay all his expenses so he can one day possibly own the residence makes, again, no sense. So here's what the court is going to do at this time. The petitioner shall continue to pay the expenses she has been paying through the month of May. That is essentially 10 months, if not more, of which the respondent should have had a job to pay these expenses. It may not be the job that he just wants, but there is nothing that shows this court that he's making a true effort to find employment. Respondent is to pay the first mortgage, utilities, homeowners, insurance, and property tax until the home is sold. The respondent shall reside in the home to be sold until it sells. Then the road in Castle Rock shall be listed for sale immediately with an agreed upon realtor. Proceeds are to be placed in Chad Zandy's trust account. Meanwhile, the respondent shall clean and maintain the residence in a manner appropriate for having a home on the market. If he's not working a job, then there's nothing that should stop him from taking care of that home, making sure it's maintained, making sure it's clean, making sure any junk is removed. If the respondent wants to remain in the home come June and or to keep it, then the debts associated with the house shall become solely his responsibility. The house shall remain on the market and the respondent shall maintain it in a manner appropriate to being up for sale. The request for petitioner use property in her possession and 2015 Chevrolet Silverado and the list of items that is granted. Sounds like you were asking though for a little bit more than that, Mr. Zandy, more than that list or not?
I didn't want to get it. There's like the personal effects on belongings that are inside the house of people collecting stuff over 7 years, which I'm always loath to include that in a motion for temporary orders. Okay. Again, given that, Ms. Rush and I do communicate very well, I have no problems with getting a list of her, keeping that outside of the court's time and resources. But yeah, if we could just get a day or several hours to go in there and get what we need to, provided we can find it. So I think the list is important. I'm confident that Ms. Rush and I can coordinate that through our staff or through ourselves.
So I'll just leave that to counsel to work out that part of it. I'm not going to get into details on all of that.
That's fine.
The respondent will use the property in his possession, obviously not intending that to be everything in the house, minus those items that are to go to the petitioner, plus the 2005 Ford Taurus. And then the request for protected property, neither party to move, take, hide, damage, etc. That request is granted. Now, in regard to the credit cards and being maxed out, the parties are going to have to look at priorities. What needs to be maintained? What needs to be kept to preserve? And it may be that it's a situation where the parties need to take priority as to what gets paid at this point. I don't know. Neither party is necessarily bringing in a whole lot of money. At the same time, they need to preserve their residences and make sure that those are taken care of. but I'm going to go ahead and order that the respondent pay the American Express credit card and Citibank credit card, and the petitioner pay the mortgage on the other house. I don't recall what it's called, including taxes, insurance, as well as the Red Canoe credit card. The request to not change insurance, that is granted, and the second real property can be occupied or rented and used by the petitioner to what she needs to do at this time. Each is to pay their own attorney's fees.
And Judge, part of the request on that, and I was writing as fast as I could, was to disperse some money upon that house sale. We suggested that 20,000. Is that, I guess, ordered or agreed?
That's fine with that. That's fine with us.
Okay, that's fine. I missed that.
And that will hopefully help with their expenses.
Okay.
Presentation, 2 weeks.
So we can go on the 21st.
That works.
That works for me, Your Honor.
Okay.
And do we also want to include in that order that both parties are to cooperate with the agent and any material disputes are resolved by said agent?
Any objections to that, Ms. Rush?
That's fine, Your Honor.
Okay, you can include that.
Okay, thank you.
All right.
Amy Powers here for Ms. Wolski.
I'm fully appearing for Mr. Torres, Your Honor.
And Height, guardian ad litem, Your Honor.
All right, counsel, go ahead on your motion.
Thank you. We have two different motions before the court today. We have a contempt motion and also a motion for other relief. Does the court want to hear those argued separately or together?
You can go ahead and argue them together.
Okay, thank you. I know that the court has reviewed all of the records, so I will be brief. I'm going to start with the contempt motion. We filed a motion for contempt because Mr. Torres has violated two different provisions in the parenting plan. Specifically, he's violated paragraph 8 of the parenting plan, which sets forth his visitation schedule. His time with the child starts at 5 p.m. on Wednesdays and 5 p.m. on Fridays. Despite this order, he has repeatedly picked the child up early from daycare, including as early as 10:20 in the morning. We provided proof of 11 different incidences when he did this and set those forth in our motion. He has also violated paragraph 12 of the parenting plan, which requires Mr. Torres to use a third party to provide transportation for the child. Mr. Torres argues that that provision was only in place because of a protection order that was in place at the time the parenting plan was entered. The protection order expired February 13th, and Mr. Torres has been at every exchange since that expired. Although it's true that there was a protection order in place that expired, the provision in the parenting plan says nothing about being subject to the protection order expiring. And Mr. Torres being present at the visit exchanges has been upsetting to my client and a stressful situation. So these are pretty straightforward. Mr. Torres doesn't deny his behavior. He's violated both of these provisions. They're straightforward provisions. We're asking the court to find him in contempt, and we're asking for $1,000 in attorney fees payable within 30 days based on this contempt motion. Moving on to the other motion that we filed, there's 6 pieces of relief that we're asking for in that motion. The first thing that we're asking is that the court correct a clerical error in the parenting plan, temporary parenting plan that was entered December 12th, 2023. According to the clerk's notes, weekend visitation was ordered to end Sundays at 5 p.m. and the parties have been exchanging the child Sunday at 5 p.m. Nonetheless, the order that was entered by the court shows that visitation goes until Monday at 9 a.m. We believe that's a clerical error, and we ask that the court correct that. Next, the parties have been separated since September, and my client has personal property that's still in Mr. Torres's possession. We're asking the court to set a date certain for that to be exchanged. We've tried through the attorney's office to negotiate this. In Mr. Torres's response, he did indicate he has it set aside, so I'm hopeful that this means we can arrange for pickup soon, but I'd still ask the court to set a date certain for that to be done, or at least follow up on this at the presentation date if we have been unsuccessful exchanging the property by presentation. We asked to change a weekend in July, and Mr. Torres has agreed with that, so I won't say anything about that. Our fourth request was that Mr. Torres be prohibited from driving with the child. DCYF made a founded finding for negligent treatment based on reckless driving, which was made against Mr. Torres, and this child Mason was part of that finding. The finding specifically says that he put her at significant risk of being injured or killed based on his negligent driving. Mr. Torres indicates he does have a valid license. The GAL filed her preliminary report and also mentions concerns about his driving. So we would ask that the court prohibit him from driving with the child. Fifth, we ask that the court order that Mr. Torres destroy any videos and photos, explicit videos or photos that he would have of my client. He indicated in his response he's already done that. We would still ask that that language be in an order in case any new videos or photos surface or are found. Lastly, we're asking that the child be required to sleep in her own bed during visitation. She sleeps in her own bed at my client's house. There's no reason why she shouldn't be sleeping in her own bed at Mr. Torres's home. And that's our request for today.
Mr. Foley?
Thank you, Your Honor. I think the last one is agreed. The videos have been destroyed. As far as driving with the without the child, Your Honor, my client is under the microscope as a result of a driving charge that occurred prior to the case being filed. He is currently under the microscope, obviously, as part of his resolution of that case. He does have a valid license. He does have proof of insurance. And there's no reason to suspect that he is going to risk his contact with the child by doing something stupid in terms of his driving. So we would ask that that remain in place, not to mention the fact that it would be extremely difficult for my client to have to try to round up third parties to provide all of the transportation. My understanding is the change of weekends requested by mother has been agreed to by my client, provided that there's adequate makeup time, and I think that issue has been resolved. Counsel's correct. The personal property has been set aside. My client's only objection was Ms. Wolski coming through the house, so he has set those things aside. As far as this matter being I guess paragraph 12, paragraph 8, I believe, is the visitation schedule. It is not, I would argue that it is not a clerical error. Judge Evans entered this order back on December 12th, and I recall it very specifically because Ms. Wolski wanted to make a number of changes, and Judge Evans basically said, look, the order has to reflect what my ruling was. And it says here specifically, the court addresses Ms. Wolski regarding the court has already made a ruling, and the orders presented today need to reflect that ruling. And then the court addresses Ms. Wolski regarding a new concern that would be need to be addressed with a new motion. Court signs the temporary parenting plan. And then the rest of it, he asks Ms. Wolski, do you have any questions or objections? And in each of those instances, the temporary parenting plan, temporary family law order, and the protection order, Ms. Wolski is noted in the clerk's records as having no objections. And I would argue that there's a distinction between what we call the November schedule, which was just alternating weekends, that changed in December of 2023. You'll note in paragraph 8, as of December 2023, Mr. Torres has the first, third, and fifth weekends for his visitation. And there's nothing in the materials would say that, since the child is in daycare, not school, but in daycare, there's nothing in there that says he's prohibited from picking the child up any earlier. And so I think that's consistent with Judge Evans expanding his time. As of December 2023, he wanted Mr. Torres to have more time with the child. Now, he's not showing up at mother's house in order to exercise this visitation. It's not impacting mother in any way. And so I would ask the court not to find contempt on that. I believe it's just a father wanting to spend time when he has the time with his child. And again, there's nothing specific in the order prohibiting that. As far as the pickup issues at the school, I did have a chance to look at mother's schedule that she provided from the school, but there's no documentation from the school saying that father is deliberately ignoring an order that he is supposed to sign the child out, and he's not doing that. It's clear that every time in the allegations that mother raises, every time my client picked the child up, the child has been signed out, whether it's somebody from the school doing it when he's picking up, or somebody, a designated third party, when he has somebody do that for him. So without more from the school saying that this is clearly a violation, I don't believe that that's necessarily a violation of any kind of an order. So the issue with regard to Mr. being present, if you look at the parenting plan, Judge Evans basically said, and I believe this has more to do not so much with the protection order, but with the allegations of driving. There was a reckless driving charge pending at the time, and Ms. Wolski made mention of that to Judge Evans. And I think it was on that basis that Judge Evans said, okay, we'll have a third party provide transportation. But there's nothing in the order, the parenting plan signed in December, there's nothing in the protection order that indicates that my client can't be present for that. As a matter of fact, if you look at the protection order, there is no distance restriction. Judge Evans was aware that my client would be present at the exchanges, primarily because the child didn't know the third party that was going to be picking her up. And so I believe Judge Evans felt that, okay, I'm not going to allow him to drive until this reckless driving thing is resolved. But it is appropriate for him to be there to sort of ease the transition of the child. And so I would suggest to the court that when you look at it, it just says a third party will provide transportation. There's nothing further that says Mr. Torres is prohibited from being present. He has not had any contact at those exchanges. I will point out to the court, though, the parties have had extensive texting contact regarding the child's illnesses, schools, pickup, things like that. So they do seem to be, working through that. But it's been a significant amount of time since the December order, and my client has not, violated any provisions as far as having any contact. And I think Judge Evans felt that was important. That's why he put a pretty quick expiration date on the protection order. As far as any comments regarding the guardian ad litem report, none of the guardian ad litem report, in my opinion, is properly before the court today. There was no motion to adopt any particular section or recommendation. So I will not address any issues relating to the GAL as I believe those items aren't properly before the court. Thank you, Your Honor.
Ms. Powers?
Thank you, Your Honor. Just briefly in reply, in regards to the clerical error in the order, if you look at the clerk's notes from November 21st, 2023, which were filed attached to my client's declaration, on page 2, the court clearly says alternating weekends 1st, 3rd, and 5th from Friday 5 p.m. to Sunday 5 p.m. Midweek visits 5 to 8 p.m. That is where I got the information. I was not involved at the time these orders were entered, but the clerk's notes set that out clearly, that visits are supposed to end Sunday at 5 p.m. And that's what the parties have consistently done since this order was made. So I asked the court to correct that clerical error. And then in regards to the contempt, the visit is, or the pairing plan is clear on its face. Mr. Torres's visits begin at 5 p.m. The order does not say they begin as soon as Mr. Torres gets off work and is available. They say that the visits start at 5 p.m. He is in violation of that order because he's been picking her up significantly before 5 p.m. And again, the order says Mr. Torres must use a third party to do exchanges, and he has not been doing that. So I do ask the court to find him in contempt and grant the relief we have requested.
Ms. Height, anything you wanted to say at this point?
I filed my report on the 15th of April, and if Your Honor has had a chance to look at it, there are some pretty serious concerns addressed, and the recommendations that I put forward reflect the concerns that have been stated here and go further than my recommendations go further than what is being discussed here. I don't know if Your Honor wants me to address any of that. I also had a conversation on May 2nd with Naomi Frine, the CPS worker who has been involved in this case. She expressed similar concerns to some of what I have detailed in my report. I will be writing some of this up in a future report, but for the court's consideration today, she feels like a third party is necessary for this child's safety. She also felt strongly that overnights at this time, until more information is available through professional evaluations, that overnights are not a good idea at this time. So that's some small amount of further information. I recognize you're not looking at my report today, but my concerns are I am extremely concerned for the safety of this child.
All right, thank you. So first off, in regard to the motion for contempt, a parenting plan is very clear as to times that are to be followed and are required for a parent as to their visitation time. So the court finds a willful and intentional violation of the court orders of this court, and the court does expect compliance with its orders. Mr. Torres has failed to do so by picking up the child prior to the stated time he is to have the child. If it says 5 o'clock, and that's what it is, and to make it his own time is not appropriate. I'm glad he's had good times with the child, but if it says 5 o'clock, that's where it needs to be. As to him coming to the exchanges of the child as well as driving to at least some of the times, I find the language a little vague as to that part of it. So the court cannot find him in contempt as to that particular section of being paragraph 12, page 3, states the child will be exchanged for parenting time, picked up and dropped off, daycare or school, if not in session, then at Hall of Justice. A third party will provide transportation for Luciano. It does not specifically prohibit him. And if somebody's prohibited, the court finds that it needs to be clearer as far as that part of it. So the court cannot find contempt there. Mr. Torres can purge the contempt by complying with the order, properly signing in and out the child as required by the daycare, which again is not a part of the contempt specifically, but to say that that's part of the responsibility of a parent when picking up a child. It's for the daycare to know who picked up the child. It's for the daycare to know when the child was picked up and to help keep track of the children in their care. So that is to be followed. As far as attorney's fees, the court does order $1,000 in attorney's fees for the necessity of the respondent having to bring this motion. In regard to the other request, number 1, the clerical error can be corrected to that of Friday at 5 p.m. until Sunday at 5 p.m. It's very clear in the clerk's minutes on November 21, 23, that it is supposed to be Sunday at 5 p.m. So that correction can be made. Any further modifications or changes to that parenting plan, the court finds that it's necessary to bring a motion to specify what additional modifications need to be made. With the guidelines report out, it sounds like it might be appropriate to do so, but I'll leave it up to council to figure that out. As to the date certain to receive personal property, it sounds like things have been put together by the father for the mother to pick up. I'll just leave it to council to figure out a date that works for your clients to exchange those items or pick up those items. It appears that it's agreed upon about the weekend in July, and the idea of a makeup weekend on the second, sounds like maybe the second weekend of the month might be a good idea.
Did we get to agree to that? I wasn't in agreement with that. I thought we were going to discuss.
Sir, stop. So in regard to Mr. Torres driving the child, again, that one's difficult. I would ask that a motion be made if that's the request, because the language simply isn't clear about that. As long as he's properly licensed and insured, the court's not going to find an issue as to that part of it. The child shall be in a proper seat for a child of that age. As far as Mr. Torres immediately destroying any intimate images, a video of the respondent, and Also shall not distribute, publish, or share any of those images or videos that can be included. Sounds like he's already done that. That's great, but that will be included in the order. As to the minor child is not sleep in the same bed, again, it sounds like that's in agreement. That's only appropriate. And so the child shall have her own bed during visitation with Mr. Torres. And the other one had to do with the hot tub. It sounds like it's already been secured. So you can go ahead and include it, but it sounds like Mr. Torres has already taken care of that as well.
That's correct.
All right. Anything else, council?
Thank you, Your Honor.
Can we set this for presentation in 2 weeks?
We can set it on the 21st.
All
Does that
right.
work for you, Mr. Foley?
Yes, Your Honor. Thank you.
Okay. All right.
Thank you.
Thank you, Your Honor. Thank you, Council.
That includes this matter. And I don't have anything else. Is there anyone on here that thinks that they have something else today? Hearing nothing, I will end this Zoom session.